All right, welcome back. This is still the Polity. That there was a report of happenings on Friday where the Supreme Court ruled that the old notes should continue to be in circulation until December 31st, 2023. That's to the end of the year, so to speak. It happened after some states took the federal government to court over the new Naira swap policy. That we'll be discussing right now, and also the issue of 25% rule in the FCT as regards presidential election and the declaration of a winner from the Constitution. That we'll be discussing right now with Mr. Confidence Mbang. He's a legal practitioner. Welcome to the program.
Thank you very much.
All right, let's start with the issue, the report we saw there, the Supreme Court ruling.
Yes.
I'd like to get your general thoughts on the matter, especially after the whole hula baloo where Nigerians have been waiting for that decision, and it finally came on March, I think that was March 20. I can't quite figure out the date, but it was on Friday anyway.
Yeah,
what are your thoughts about that decision and what happened in general?
Yes, first of all, I must establish the fact again that I'm non-partisan in respect of my discourse. I'm discussing law and not politics. Yeah. Now, the issue of the Naira redesign, from onset, it was a good policy. It is a good policy due to the rationale given by the federal government in respect of that. Now, in the execution of same, so many things happened. So many things, ranging from institution of actions by several states, led by the Attorney General of Kaduna State under the authority of Governor Nasser El-Rufai. And then there were so many adjournments and joinder up to the stage the matter was adjourned for definite hearing and, of course, determination of same by the Supreme Court. And what we saw then was the president, the commander-in-chief of the Armed Forces, President Muhammadu Buhari, giving out a press statement, you know, and in his speech he kind of like deviated from the ruling of the Supreme Court that, look, parties should be at status quo ante bellum. Parties should go back to the normal position, but the president said, oh no, 500 and 1,000 Naira notes should not be in circulation, only the 200 Naira notes. That caused so many legal uproar, and now on Friday, the 3rd of March, the Supreme Court gave a decision per Honorable Justice Emmanuel Agim. He gave the decision, first of all, striking out the preliminary objection of the lead counsel to the federal government, and also pronouncing that the 200 Naira notes, 500 Naira notes, and 1,000 should be in circulation till the 31st day of December 2023. The premise of that decision, Amadi, was due to the hardship that the implementation of that policy caused on Nigeria, even up till now. I can bet you that there's nobody can say he or she did not feel the impact of this policy. Even I myself, I felt it so much, and now the Supreme Court have come out to say, look, let this note be in circulation till 31st. The position of the law is simple. The federal government must. It's a matter of must. It's not may. They must comply with the judgment of the Supreme Court. And I'm telling Nigerians that Nigerians should henceforth continue to use the old note. That is law. The decision of the Supreme Court on any matter is final by virtue of section 235 of the 1999 Constitution as altered in Adegoke Motos against Adesanya. The Supreme Court per Oputa JSC stated that we are final not because we are infallible. We are infallible because we are final. The Supreme Court is final on any adjudicatory matter.
All right, I love that statement.
No, please. Amadi, we operate the doctrine of separation of power propounded by Baron de Montesquieu, I think a French philosopher. The duties of the executive, legislature, and judiciary are clearly spelled out in the Constitution, section 4, 5, and 6. Why the legislature makes law, the judiciary interprets, why the executive implements. That is it. Let us abide by the decision for purposes of saving the face of this country. I bet you, after the governorship elections, if the scarcity of Naira continues, there will be problem in this country.
All right. I love that statement so much. You know, it's always good to hear from legal practitioners. You learn every day. He says the Supreme Court we're not final because we're infallible. We're infallible because we're final. That's interesting. Yeah. But now let's talk about the process of implementation of this matter. Yeah. From my understanding, the CBN was not a party to the suit, was it? So what I want to get now is, what is the process to getting what the Supreme Court has said? The Supreme Court has said these notes to remain in circulation. Yes. But we know that the CBN is directly involved, you know, when it comes to monetary issues.
Of course.
So what should, as a Nigerian who I've seen this judgment, I know it exists, I know the Supreme Court has said this. Now I'm waiting for that, you know, that last thing that says, you know, go ahead. How is that supposed to come? You know, because I know it's the federal government that was taken to court. Yeah. Are we supposed to see President Muhammadu Buhari come out and tell Nigerians, Supreme Court has told me to do this, so this is how it is, go ahead? Yeah. Or is the CBN also, can the CBN just hear the news and say, you know what, we heard on the news that the Supreme Court has said this, so we are now doing this? Okay. Or, you know, what exactly is supposed to happen? Or the simple pronouncement means, I as a Nigerian now, if I have an old note, I just start using it. What is the line of implementation? That's what we want to understand. Because since that day to today, we've not heard from the president or the CBN. The CBN.
Yes, I think your concern is centered on what will trigger the compliance of the judgment of the Supreme Court. Yes. It is simple. Without prejudice to the internal mechanisms of the CBN as an agency of the government, without prejudice to how they'll get to coordinate and organize their system to start accepting these notes. Look, the decision of the Supreme Court as it has been made must start being complied with in toto. In other words, we don't need the President Muhammadu Buhari to come out and say, look, Supreme Court have said use the old notes before we may start using it. No. The pronouncement of the Supreme Court is law at this stage. All Nigerians have the right to approach any business, any bank, and continue using the old Naira notes without having to go through any form of procedures. No, the judgment stands stands and it should be obeyed. It should be followed. In other words, sir, Amadi, any business organization that refuse the old Naira note, it is invariably disobeying the decision of the Supreme Court. And that is contempt. That is contempt as fashi kuri. It is contempt.
What does that mean?
Contempt outside the court. Contempt in contempt as in you're disobeying the express order of the court. We have two types of contempt. Contempt in fashi kukuri and contempt as fashi kuri. Contempt in fashi kuri is contempt in the face of the court. Like for instance, where you in the course of proceedings you do an act that is not right before the judge. Maybe for instance you use an abusive word. That is you contempt in the face of the court. It is criminal. It is criminal. While outside of the court is contempt as fashi.
Okay, to go further on that, I want to paint a scenario.
Yeah.
As a Nigerian, law-abiding Nigeria,
Yeah.
I have the old 500 Naira notes. I head over to a place, say, an establishment, and I say, this is payment for this item, and I'm told that that money is not legal tender.
Yes.
What can I do from there?
Well, I get...
Let me put it this way. What could happen to said person for not, or let me put it this way, it is it, have they committed any crime by rejecting the money?
Well,
what could happen to them?
Yeah, I would say they have disobeyed the order of the Supreme Court, which is now law. But then the question you ask, what happens to them? That brings us to the executive arm of government. Because while the decision has been passed, the courts will not enforce it. So as the decision has been passed, the executives must enforce it. They must implement it. In other words, the government should set out strategies to ensure that, look, businesses or companies and thereabout that don't continue using these old notes are brought to law. They should be disciplined, and there should be penalties in respect of that, because it is causing hardship. It is not the fault of Nigerians that federal government planned to change Naira notes, and now all the negative aspect of it is on the ordinary Nigerians. You need to see how people are suffering. We now practically do trade by barter in Nigeria.
There's an interesting part of that judgment. I don't know if you can throw more light on the way it takes account of hardship of Nigerians.
Yes.
I don't know. I always expected the decision would hinge on something of a technicality that, legally speaking, the president cannot do this at so time, and so, you know, I was a bit interested to hear that into the judgment it was taking account that it's caused hardship. I'd like to, you know, hear more about that. You know, is that something that is expected that happens, you know, in judgments?
Yeah, of course. It happens. It is natural that in judgments there are essentials of a judgment. You know, the judge must put forth the facts, the law, analyze them in the light of the evidence placed before the court and all of that. And then when he's giving his judgment, he does not just state the law. No, he marries the law with the evidence laid before the court. In other words, that is what the Supreme Court in Mogaji and Odofin Bello has said. The judge will place the evidence in an imaginary scale to weigh it and determine where it tilts to. Now, in passing the judgment, we have the ratio decidendi and the obiter dictums and commentaries and whatsoever. The ratio is the reason behind the judgment. Obiter dictums are the statements made by the judge, statements that try to complement the reason to his judgment. So if the justices of the Supreme Court pair, let's say the lead judge, Emmanuel Agim, I saw it when he said the policy have caused so much wahala, so much brouhaha. It has caused so much upheaval to the ordinary citizens of Nigeria, people suffering there and all of that. It is natural, and those are the circumstances that led to him giving that judgment. Why? To ameliorate the hardship that policy has bestowed on Nigerians. So it is natural, and it is good judgment, if you ask me.
All right. So finally, on this issue, I'd like to know what you think about the future of the country as regards enforcement of orders. You know, I always ask this question whenever I'm able to have a discussion with a legal practitioner. There was a period where I remember some courts gave orders. One court ordered that the EFCT boss be remanded, I think, in Kuje Correctional Facility. Yeah. Another court also ordered that the IGP be taken to thereabouts. The commentary around by the layman was that it's not going to happen. There's no way those people can be touched. So there is an issue where a pronouncement is made and then the implementation is the issue. Yeah. What do you think is the way forward for this? So that when something like this happens, the judiciary, the executive doesn't have that option to think and say, should I comply? Should I not comply? When should I comply? You know, those kind of things. What do you think can be the way forward, where once the pronouncement is made, there's no, except you are going at it in a legal manner yourself, but there is no question about whether it should be obeyed or not?
Yeah, that's a very sensitive question, if you ask me, because like I said, we operate separation of powers. The executive implements, we interpret, the legislature makes the law. Now, the issue of implementation should not be swept under the carpet, because we have seen so many court judgments being not complied with by the persons they relate to. And it has been an issue. Now, on the aspect of the judiciary, they are not relaxing on that. And of course also, it depends on the nature of case and the counsels involved. Because after a court delivers its judgment in your favor, you cannot just sit down and fold your arm and expect the judgment to execute itself. No. You have to take necessary steps for the execution of judgment. That is what we call, execution of judgment, of course. That is what we call it. But for your question centers on high-profile citizens. When they say you must do this and you discover that nothing happens. Nothing happens at all. Man, it is not a good one. It is not healthy for our legal system. And so I would say it demands a combined effort between the executive and the judiciary to ensure that when judgments are delivered, no matter the caliber of person that is involved, the judgment should be complied with.
All right. That's fair enough.
Yes.
All right, let's move over to the other matter of discourse today, the issue of the constitutional requirements to become president, including scoring at least getting the popular vote and also scoring a minimum of 25% in 2/3 of the states plus FCT. And we had this discussion before, and let's try and go further in that discussion again on the issue that the main presidential the president-elect at the moment did not get 25% of the votes in the FCT. Where do we go from that? Is it in any way contravening the law?
Thank you. Last week I was here and I made my position. But however, there's beauty in continuous learning and research. I'm a researcher, a prolific one. I have an open mindset. When it comes to law, I don't discriminate. No, I have a very open mindset. Now, I'll be arguing for and against, and it's simple. The proponents of the argument that you must not have 25% of votes in the FCT have done so, relying on various sections and authorities. I mean sections of the Constitution and extant laws, and decided authorities too. And of course, it's elementary now that the sections in contemplation are section 299, which defines, no, not just 299. 299 only said, look, treat FCT like or as any other state. It does not say FCT is a state. No. So the contention is 299 and its sister sections. I'll come to those sections. And section 134 sub 2b, which states that where there are two or more candidates contesting for the office of the president, they must score 25% of vote in at least 2/3 majority of all states and the FCT. So that is the contention. For those who say you must not have, they are clinching their argument on the fact that section 299 says, for purposes of the provisions in the Constitution, treat FCT as any other state. They have relied on Kayode FCDA. They have relied on Bakara and Ogundipe decision of the Supreme Court 2021 authority. They have relied on Baba Panya FRN. They have also relied on Ibori Ogburu decision of the Court of Appeal. And now their stand is that, look, if section 299 says treat FCT like any other state, then if you are reading section 134 sub 2b, the Constitution says you must get 25% of vote in 2/3 majority of all states and FCT. So you should now merge FCT as any other state, making it 37 states. So in other words, if you score 25% in 25 states, excluding the FCT, you have satisfied the conditions to be president of Nigeria. That is the argument on the one hand. That is the argument on the one hand. On the other hand, the proponent that of the view that, look, you must have or get 25% of votes in the FCT too, have clinched their argument on the gimmicks of interpretation of the Constitution. They are saying that, look, the provisions of Section 2, Sub 2, which establishes the state and the federation, 3 Sub 1, Sub 2. 3 Sub 1, Sub 2 mention the 36 states and their geographical locations. 3 Sub 4 mentioned FCT and established it further in Part 2 to the first schedule of the Constitution. Section 48 of the Constitution says the FCT shall have a senator. You get, and other states too shall have. 297, 298, 301, 302. All of them are all those, a community reading of those sections are saying that, look, FCT in one way or the other should be treated like a state. But the argument is, are you going to read those sections into Section 134 Sub 2B to make FCT part of the state? What was the jurisprudence behind the lawmakers enacting expressly, literally, that, look, for you to be president, you must score 25% of vote in not less than 2/3 majority of states and the FCT. What was the jurisprudence? They have argued that the jurisprudence or the reason of the enactment of that law is to ensure that the number one man, who is the uno numero citizen, who wants to govern so many millions of persons, garners acceptance in the seat of power, in the super state of power. For instance, in the elections that brought Donald Trump to power, Hillary Clinton won majority of votes but could not win the super states. Donald Trump won the super states. That is on a comparative view, talking about the USA. But now, the question is, Section 134 Sub 2B have not been a subject of litigation in our courts. It has not been litigated upon. In other words, there is no substantive judgment on that section. Some legal practitioners and scholars have been citing the case of Obasanjo, Buhari against Obasanjo 2003,
yes,
saying that the court noted that, look, where a candidate wins a majority of the vote, it should be declared as winner. But we sat back, went and read the full judgment that has up to 268 respondents. We read the judgment that started at the Court of Appeal, Tabai JCA, stated that, look, this matter is premised on 3 issues: non-compliance with the Electoral Act, that is, non-compliance in the election between Buhari and Obasanjo with the Electoral Act, corrupt practices, and the fact that the qualification of Obasanjo was in dispute. Section 134 Sub 2B was never in dispute. Where Section 134 Sub 2B just Nicodemously came in was when the elections in Osun State, the presidential election in Osun State, was cancelled. And then the appellant were saying, all the petitioners were saying that, look, since the election in Osun State was nullified the whole election. Ejewumi JSC said no, that we cannot hold such. It is impossible that for purposes of the fact that election in Osun were cancelled, so the whole elections should be cancelled. That was the only instance that the Section 134 came into that judgment. And so to me, it is no authority at all for this argument. Now, how do we interpret Section 134 sub 2b? That is the question. Amadi, there are canons or rules of interpreting the Constitution and statutes. The first recourse to interpret the Constitution is the literal rule. In other words, what it says, give the Constitution all a statute. It bears meaning. You know, if it says, if the Constitution or statute says, Amadi, come here, interpret it like it is saying, come here. Don't try to meander about. That is the literal rule as stated in Attorney General of Abia State and the AG Federation 2021. And again, sir, where words are clear and unambiguous in the Constitution or the statute, they should be given their ordinary meaning.
Interpretation.
How's the decision of the court in Kashim, Sadiku, SDP, and there are plethora authorities on that. In fact, some of my colleagues, while we engaged in so much banter on this, raised an issue that, look, the Supreme Court has stated that in interpreting the Constitution, you should consider all the whole sections dealing on that issue. In other words, in respect of this issue, we should consider 2 sub 2, 3 sub 1, 4, 48, 297, blah, 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 all those sections. I told them, no, go back to the law, go back to the decision again and study it well. And I cited the case of Enoch Bama Osage, where the Court of Appeal took time to demystify the decision of the Supreme Court in Elelu Habib and others against FRN, where Adekaye JSC stated, and I quote, he said, in interpreting the Constitution, the provisions should be taken or examined as a whole, unless, emphasis on unless there is a clear reason why the whole provisions should not be read as a whole. In this case, Amadi, there is a clear reason, according to the proponents, because I'm arguing for and against, according to the proponents that says you must get 25% in FCT, they are arguing that there is a clear reason why we should not consider all those sections that deals with FCT, and we should give section 134 sub 2b it clear, literal, unambiguous, and natural meaning.
All right, Mr. Confidence, I'm back. It's been really interesting to hear you. We've heard for and against. At the end of the day, I don't know if are you going to be the judge to tell us for or against, or is that up to Nigerians that have heard you to decide for themselves?
Yeah.
But anyway, do you think we might be finally seeing it? You know, you said that there's no. Well, how did you put that language? Officially, no court has ruled on that.
No court.
Could
no
we
court.
be seeing that this time around?
Well,
I mean, have you heard of any of that clause being challenged so far?
Well, there are suits. There are suits. I mean, the Labour Party presidential candidate, Mr. P2B, is in court.
All right.
And of course, his suit is centered on nullification of the election and all other things, requirements and all that things. So let's be futuristic on that aspect. Amadi, for instance now, if I say I want to see 4 children and Jacob, and then 4 children and Jacob, it means I want to see 5 children back. So if 5 children come and Jacob is not among, have I seen what I wanted to see?
All right, so we'll end it there. Thank you so much. Thank you so much. That's the question we'll leave you with. Has he seen what he wanted? Jacob is not there. Well, anyway, thank you so much for coming. It's always a pleasure to have you. And that's all we'll take now on the program. Do join us tomorrow, every weekday, 2 p.m. to 3:30 p.m. for the Polity. Have a nice day. See you tomorrow. I'm Amadou Nubari.